Good day, everyone. My name is Mайлін Dімітрі, and I'm lead counsel before the International Criminal Court. I represent Mr. Alfred Rombot-Yekatom, who is charged with several charges of war crime and crime against humanity for events that occurred in 2013, 2014 in the Central African Republic. I have been a defense counsel before international courts and tribunals for 20 years. I've practiced before the International Criminal Tribunal for Rwanda, before the International Criminal Tribunal for former Yugoslavia. I practiced before the Special Tribunal for Lebanon, and I've also conducted a genocide case in Canada. Today, I was asked to talk about sentencing. So before we start with my introduction, I will explain briefly the topics that I will address in terms of sentencing. I will first discuss the purpose of a sentence. The second point of my presentation will be comparing sentences to other tribunals, courts, or national courts. The third point of my presentation today will be the sentence has to be determined by relevant items of evidence. The fourth point that I will discuss during my presentation is the difference between the perpetrator and an accessory to a crime, the superior and the subordinate, again in terms of sentencing. I will discuss in depth the range of various sentences, and more specifically, what can be qualified as an aggravating circumstance, or what could be qualified as a mitigating circumstance, and the burden of proof for both. I will also discuss briefly the individual circumstances of the convicted person that must be taken into account. I will also discuss double counting and explain the various situations where you have to be aware of double counting and oppose it or argue against it. And as my 7th points during my presentation today, I will discuss whether or not aggravating factors for a sentence must be indicated or listed in the indictment or in the charges. And finally, I will discuss credit for time served and concurrent sentences. So before we start with my first point, which was the purpose of a sentence, I want to underline that it's important to always bear in mind the sentencing stage. Sentence has to be kept in the mind of a defense counsel at all stages of the proceedings. First, when you meet your client, because you can't promise that you will win the case. You can't promise that you'll have an acquittal. So you always have to bear in mind your client's interests, of course. So in order for him to take an informed decision as to whether or not he's ready to go to trial, you have to be in a position to present him with the various possibilities, and those possibilities must include what he's risking. What is the highest sentence he could get for the crime he's facing? So you have to do a comparison with the various cases that were tried before the institution you're conducting your defense, in order to be able to inform him of the risks he's facing. It's therefore important that when you take a case, you as a defense lawyer have a look at the evidence, how strong it is, and discuss the sentencing with your client. You also have to keep in mind the various mitigating factors that he will discuss with you, because they could be used at a later stage. So it's always important when you're questioning witnesses, when you're conducting the trial, to put into evidence mitigating factors, because as we will see later on in this presentation, the mitigating factors will be important at the sentencing stage. So although when you take a case, you think, well, sentencing is the last thing I must think of, I always bear it in mind, even when I start a case. It's the first thing I discuss with a client. What are the charges? What are you risking? And then let's discuss whether we go to trial or not. As I said earlier, the first point of my presentation today is the purpose of a sentence. In Article 50 of the Criminal Code of Ukraine, there is a definition of punishment and its purpose. And it's quite similar to what we have before international courts and tribunals. So Article 50, subparagraph 1 states that the punishment is a coercive measure imposed. And subparagraph 2 indicates that it's also, its aim is not only to penalize the convicted person, but to prevent further offenses by the person, the convicted person, but also others. So it has to have a deterrence effect, which we have also before the International Criminal Court. At the International Criminal Court, retribution and deterrence are the primary objectives of a punishment. So it's very, very similar to the Criminal Code of Ukraine. So the various factors, the various points established by the jurisprudence of the International Criminal Court could be used as well. You could argue them because the purpose is the same. It's similar. However, at the International Criminal Court, it was the various chambers underlined that retribution is not to be understood as fulfilling a desire for revenge, but it's an expression by the international community that condemns the crime. It's an expression by the international community who is recognizing the harm to the victims, and the international community is expressing its wish to promote the restoration of peace and reconciliation. And this is what's meant by the purpose of retribution. It's the international community who's saying to the victims, because the victims have a very important place before International Criminal Court, who's saying to the victims, we recognize the harm that you suffered. So a sentence should be adequate to discourage. A sentence should be adequate to discourage a convicted person from committing the crime again. That's the deterrence effect. But it's there to ensure that those who would consider committing similar crimes will be dissuaded from doing so. So there's the specific deterrence and the general deterrence. And in national jurisdictions, we often see that rehabilitation is a relevant purpose for sentencing before the International Criminal Court, because of the gravity of the crime, because of the crimes we normally deal with, because of the circumstances in which those crimes have been committed. rehabilitation should not be given undue weight, which is what was stated by various chambers. It is for this reason that, and I'm coming to point 2, also comparing sentence to other tribunal or court or national court is not always a pertinent exercise. First, because if you want to compare, for example, various sentences from the International Tribunal for Former Yugoslavia to sentences given by the International Criminal Court, the statute of both institutions is different. So even though there are similarities in the sentencing provisions of the International Criminal Court and of other international criminal tribunals, the court has to apply, in the first place, its own statute and its own legal instruments. So it's not always pertinent to compare the sentence. In addition, and the same principle applies before national jurisdiction. The sentencing an individual for crimes he committed is a unique exercise. So comparing, entering into a comparison exercise is a very limited relevance. So I invite you to not look at the numbers and try to argue that a similar number should be given. What will be important are the various factors that we're taking into account. And we will have a look during this presentation at the various factors that must be borne in mind when you're arguing on sentencing. The third point of the presentation today is the fact that the sentence is determined by relevant items of evidence. So you always have to make sure as a defense counsel that what your counterpart is arguing in order to obtain a higher sentence, the facts that he's relying upon to obtain a higher sentence is in evidence. It has to be in evidence. He cannot or she cannot argue facts that are not in evidence. So always bear in mind when arguing on sentence that they are relying on factors and facts and circumstances and events that are in evidence and that are proven. And for that reason, in the course of the trial, and I said earlier, always bear in mind the sentence, in the course of a trial, always be careful when your counterpart is asking additional questions or bringing additional evidence that is not necessarily related to the crime. It would be too easy to say, well, it doesn't relate to the crime, so I'm not going to question the witness on this incident. You have to bear in mind that it could always be used at a later stage as an aggravating factor because it's evidence and because it's negative evidence against your client. So always be ready to object to additional evidence that's not announced, just to make sure that you're always limiting the damages for your client, that you're always limiting the prejudice because this could be used at a sentencing stage. And because you can't promise your client an acquittal, you always have to protect him as well, protect his interest with evidence that could be used at a sentencing stage. The fourth point of my presentation is the difference between a perpetrator, an accessory to a crime, a superior, and a subordinate. There's a very important principle before international criminal courts and tribunals, and it's the fact that the distinction between the responsibility of a perpetrator and the accessory to a crime does not, under any circumstances, constitute a hierarchy of blameworthiness. So a perpetrator, the direct perpetrator of the crime, is not always viewed as more reprehensible than an accessory. And those in command, the superiors, those in command, even though they are not at the immediate location of the crime, even though they're not present at the immediate location of the crime, and they might be unfamiliar with how the crime was specifically committed, well, these commanders are not necessarily less culpable than the direct perpetrators. Why? Because a position of authority, a commander, can be used as an aggravating factor. Why? Because the principle, the mentality is that a commander, a senior, should know better. He should lead by example. And for those reasons, there is quite some case law on the fact that the position can be used as an aggravating factor, because the command should have led by example, because he has many years of experience, because he knows better. So it's not because he's removed from the immediate location of the crime that his sentence should be lower. So there are some case law, there is some jurisprudence that states that the more senior an accused is in the command structure, the more severe should be the sentence. And we will look in more details as to the position of authority that may be used as an aggravating factor in sentencing. There are exceptions, which we'll discuss later during this presentation. However, what you need to bear in mind is, and I spoke about it earlier when I mentioned that the sentence has to be determined by relevant items of evidence. You have to bear in mind that the accused, the position of authority, or the accused superior position has to be proven at trial if your counterpart, or if the judges want to use it as an aggravating factor in sentencing. So it has to be proven. There are some examples. The fact that an accused was a prominent official could be used as an aggravating factor. The fact that he's a member of the government is not in itself an aggravating factor, but his abuse, the abuse of that position is. And there are some positions such as the mayor of a city, which the jurisprudence said, well, it's not such a high position of authority to constitute an aggravating factor. So they are, you could use the various case law to as a mode of comparison if you're facing someone who had a position of authority. Section 5 of my presentation today is the various range of sentences, which you have at Article 65 of the Ukraine Criminal Code, which discusses the general principles of imposition of a punishment. You have limits prescribed in the criminal code, but what's important and what I want to discuss in more detail is subparagraph 3, which states that the sentence has to take into account the degree of gravity of the committed offense, which is a principle that we also have in before international courts and tribunals. We're going to discuss later on the gravity of the crime, the character of the guilty person. So you will often have the use of the term the individual circumstances of the accused before the International Criminal Court. So this is the equivalent of the character, which is a very important factor. The method and motives of the committed offense, which is also an important factor according to the Ukraine Criminal Code. The nature and extent of the damages, so you know how much the victim suffered, the harm of the victims, and the circumstances, the mitigating or aggravating circumstances. And this is what I want to discuss now. I will start with the aggravating circumstances. The aggravating circumstances are discussed in Article 67 of the Ukraine Criminal Code. You have in your code subparagraph 1, which lists 13 points, 13 factors that may be taken into account as an aggravating circumstances. Number 1 is the repetition of an offense. Number 2 is the fact that the offense was committed by a group of persons upon prior conspiracy. We will have that as well, and we'll discuss it a little bit later. Number 3 is the fact that the commission of an offense was based on racial, national, or religious enmity and hostility. Number 4 is the commission of an offense in connection with the discharge of official or public duty by the victim. Number 5, the grave consequences caused by the offense. Number 6, the fact that it has been committed by a minor. Number 6 is the fact that it has been committed against a minor, an elderly, or a helpless person. Number 7 is the fact that the offense was committed against a woman who was pregnant. Number 8, against a person who was in financial, official, or other dependence to the culprit. Number 9, the commission of an offense through the use of a minor, a person of unsound mind, or mentally defective person. So we have here the accessory to a crime. Number 10, the commission of an especially violent offense. Number 11, the commission of an offense by taking advantage of martial law or a state of emergency or other extraordinary events. So the fact you could have, in the specific case of the war in Ukraine, as a factor, as an aggravating factor. Number 12, the commission of an offense by a generally dangerous method. And number 13, the commission of an offense by a person in a state of intoxication or from the use of alcohol or narcotics or other intoxicating substances. What's important to bear in mind is that subparagraph 2 indicates that you are, if a judge is not going to be taking into account some of these aggravating factors, he should provide the reasons for his decision in the judgment. And what I'm going to do is I will give you a list of principles in the international jurisprudence where specific factors cannot be taken into account as aggravating factors, which are arguments you could use to argue before your judge. Well, subparagraph 2 says that you can not take into account the aggravating factors if you provide reasons. And Your Honor, these are the reasons. I will give you some reasons when we go into more detail in a few seconds. Subparagraph 3 is extremely important. When imposing a punishment, a court may not find any circumstances other than those that we have just listed, other than the 13 points. One of the principles that need to be always applied in the international criminal courts is that aggravating circumstances must be proved beyond reasonable doubt. However, mitigating factors must be proven on a balance of probabilities. So only those matters which will be proved beyond reasonable doubt may be used as an aggravating factor. So you have to bear that in mind. Not only have to, we discussed earlier that they had to be in evidence, but they have to be proven, and they have to be proven through to the burden, which is beyond reasonable doubt. I will now give you a number of examples of aggravating circumstances. The number of victims may be an aggravating factor. Even in a case of extermination, where the number has to be high to support a conviction for extermination, if the number of victims exceeds what's necessary, it can be used as an aggravating factor. The harm caused to a victim and its family is an aggravating factor. For example, in a case of mutilation. So we saw earlier that the harm to the victim is one of the factors among the 13 points. The young age of the victim is an aggravating factor. However, we will see in a few minutes that there are some cases where you cannot count the young age as an aggravating factor because of double counting. To be raped in the presence of other people, compounds or public humiliation constitute an aggravating factor. We saw earlier among your 13 points that if you act within a group, it's an aggravating factor. So that could be the case of a specific rape, or the specific circumstances could be an aggravating factor. So, for example, if the rape is conducted in public and with public humiliation. I now want to discuss mitigating circumstances. Article 66 of the Ukraine Criminal Code lists and discuss circumstances mitigating the punishment. There are several that are listed. There are 9. Surrender, commission of an offense by a minor, commission of an offense by a pregnant woman, voluntary compensation or losses, or repairing of damages are mitigating factors. The commission of an offense in consequence of a train of adverse personal, family, or other circumstances. Under the influence of a threat, coercion, or financial or other dependence, you could have cases like that where the soldier has a constant threat by his superior or by others. This could be used as a mitigating factor. The commission of an offense under influence of strong excitement raised by immoral actions from the victim. The commission of an offense in excess of necessary defense. So if you have a case where your soldier was trying to defend himself, but he exceeded what was necessary, so he's found guilty nevertheless, well, this could be used as a mitigating factor. And point 9, undertaking a special mission to prevent or uncover criminal activities of an organized group, where this has involved in committing an offense. Contrary to the aggravating factors, subparagraph 2 of your criminal code at Article 66 states that the court may find circumstances other than those 9 that I have listed. So by looking at the International Criminal Courts and Tribunals jurisprudence, which listed a number of mitigating factors, I will try and give you ideas on other mitigating factors that you may use, since you are not limited. Again, bear in mind the burden of proof, which is not proof beyond reasonable doubt, but on the balance of probability. You have to bear in mind that as a general principle, the jurisprudence of international courts and tribunals states that mitigating circumstances do not have to be directly related to the offense. So you could have mitigating circumstances related to not necessarily to the offense, but to the offender, the circumstances, not necessarily specific to the crime itself. The age, so the advanced age of an accused was used and recognized as a mitigating factor. The ill health of an accused was also used as a mitigating factor. The conduct in detention was used as a mitigating factor. We even have a case law where an appeals chamber stated that the trial chamber, the first instance, erred by failing to consider the accused's good conduct in detention, which was recognized as a formally mitigating factor. Cooperation with the prosecution is a mitigating factor. However, a mere offer to cooperate is not. The cooperation must have materialized. He must have really cooperated with the prosecution. Good character, previous good character and accomplishments could be used as a mitigating factor. The fact that the accused has no prior criminal record. If the good relations of an accused family with his community is not. It really has to be related to the accused, to the convicted person. Lengthy public service to someone's country could be used as a mitigating factor. The fact that he's married and has children can be used as a mitigating factor. The social, professional, and family background may be used as a mitigating factor if you link it to the likelihood of rehabilitation. However, you have to remember that rehabilitation cannot be given undue weight. We saw that earlier at the beginning of my presentation. A guilty plea is obviously a mitigating factor. And I'm just gonna do a parenthesis here. There is an important case law before the International Criminal Court, which is called the Al-Mahdi case. Mr. Al-Mahdi pleaded guilty, and several factors were used as mitigating factors during the arguments on his sentence. So first, the fact that he pleaded guilty. Second, they considered as a mitigating factor his cooperation with the prosecution. Third, the fact that he expressed remorse and empathy towards the victims was used as a mitigating factor. Fourth, a very important factor that you must bear in mind because it might apply, the fact that he was initially reluctant to commit the crimes and he took measures to limit the damages. That was used as a mitigating factor. And finally, his good conduct in detention was used as a mitigating factor. Expression of remorse is a mitigating factor. And an accused can express sincere regrets without admitting his participation in a crime. Such expression of sympathy or compassion have been accepted as a mitigating factor. The voluntary surrender was a mitigating factor. Finally, before going to double counting, I want to underline the importance of the individual circumstances of the convicted person that must be taken into account. We saw that it was one of the factors that must be borne in mind, and it's specifically listed in the Ukraine Criminal Code at Article 65, subparagraph 3, which says that the character of the guilty person is a factor to be taken into account. Well, it is also the case before the International Criminal Court, and I invite you to read in detail the appeals judgment in the Ongwen decision. Mr. Ongwen was abducted as a child and spent several years as a child soldier in a specific armed group. And the judgment, he then committed several crimes and was convicted. And the trial chamber discusses at length the individual circumstances surrounding him. And it was a major point of appeal. And there's the appeals chamber at the majority discusses the individual circumstances, and there is an important dissent opinion in the appeals judgment. So I invite you to read that judgment to understand more the importance of individual circumstances of the convicted person. Point 6 is double counting. Double counting is quite important. I mentioned earlier in this presentation that as for aggravating factors, if the court is not going to consider specific aggravating factors, it must indicate why. I'm going to give you a series of reasons why an aggravating factor should not be considered as such. And this is the principle of double counting. So for example, when a factor forms the basic element of a crime, for which the person has been convicted. So if it's an element of the crime forming the base of the conviction, it cannot count as an aggravating factor because that would be double counting. So for example, if someone is convicted for persecution against Muslims, because there's the discriminatory intent that forms the basic element for the crime of persecution, because you need to show that he's targeting Muslim, the discriminatory intent, this cannot then be used separately as an aggravating factor. So the legal element of the crime cannot be considered as an aggravating circumstance. The same holds for when victims were children, because if in the event your client is convicted with enlistment and conscription of children under the age of 15 years and they're using hostilities. So if he's charged with what we call child soldiers, enlistment and conscription of children under the age of 15, it's the proof, the evidence that they are under 15 and that he used them and listed them in his group, and that they are therefore victims of his crime in such sense. You cannot use their young age, the fact that they're children, as an aggravating factor. That again would be double counting because it forms part of the legal element of the crime of enlistment. The same holds true for the mode of liability. So you cannot use an element of the mode of liability as an aggravating factor. For example, a superior's direct contribution to the crime cannot be, because he's charged with superior responsibility, and therefore the fact that he's a superior and contributed to the crime, the fact that he's a superior is an essential element of superior responsibility. You cannot use it as an aggravating circumstance. So that could be one of the arguments you could present. So where the discriminatory intent was considered as part of the common plan being another mode of liability, another mode of responsibility, it cannot be used again as an aggravating circumstance. It would be double counting. Just a small note, in the early case law of the International Criminal Tribunal for former Yugoslavia and the International Criminal Tribunal for Rwanda, chambers were double counting modes of participation and aggravating factor. They were using it twice. But later on, other chambers have rejected such reasoning. For instance, in the Blaskets appeals chamber, the appeals chamber noted that you can't double count a factor as a mode of liability and then again as an aggravating factor. Finally, on the double counting, there is the gravity of the crime. We've discussed earlier on in the Ukraine Criminal Code, gravity of the crime is a factor to be taken into account. Well, be vigilant, because a factor that is considered as the gravity cannot again be used as an aggravating factor. This would also consider double counting. So, for example, the position of someone as a commander-in-chief cannot be used as an aggravating circumstance if his position was used to discuss his degree of participation. The abuse of power cannot be counted as an aggravating factor when it's already considered in its assessment of the gravity of the crime. If the court says that, it considers in the gravity of the crime the fact that he abused his power, it cannot double count as an aggravating factor. The age of the children. So we cannot say the gravity of the offense is as such because notably the young age of the children, and then count it again as an aggravating factor. The fact that the crime affected multiple victims and their religious nature, if it's already considered in the gravity of the offense, you cannot count it again as an aggravating factor. So be aware of that. This could give you some room to attempt to get a lower sentence by being very careful in relation to double counting. Point 7 of my presentation today, very shortly, there's a distinction between the international criminal tribunals and the International Criminal Court, in the sense that before the International Criminal Tribunals, only the facts that were included and pleaded in the accused's indictment could be considered as aggravating factors at the stage of sentencing. If they were absent from the indictment, they couldn't be used by the prosecution as aggravating factors. Before the International Criminal Court, we have what we call a confirmation decision, which is the equivalent somehow as an indictment. However, the court's jurisprudence is that the factors to be considered at sentencing are not limited to the facts described in the confirmation decision. So there's a distinction here, and you might want to try and see what you can attempt in your specific case. Finally, a credit for time served and concurrent sentences. Well, bear in mind credit for time served. Wherever your client was arrested and then transferred, you can always count the time he already spent in detention, and he can get credit for time served. But this is a basic principle. And finally, concurrent sentences. You will have before the court most of the time the convicted person will be convicted for several crimes. So that the court will establish a crime. I'm sorry, the court will establish a sentence for each crime. For example, child soldier, murder under war crime, etc. And then there will be one sentence normally imposed by taking the higher sentence to be imposed in order to merge the various sentences that were pronounced, rather than accumulating one another to come up with a number. That ends the presentation for today. So always bear in mind the various arguments you can present in order to get your client a lower sentence. And I think there is room to grab some of those principles established by the various international tribunals and the International Criminal Court to be used and recycled in order to get your client a lower sentence. Thank you very much.